Good afternoon, everyone. Happy Thursday. Thank you so much for joining us today for our estate planning seminar with Heidi Klippel, Esquire. I would like to go ahead and introduce our presenter for today's event, Heidi Klippel. Heidi is a San Diego native. She received a scholarship from the William Randolph Hearst Foundation to attend the University of San Diego, where she graduated magna cum laude with a bachelor's in political science. Knowing she wanted to be an attorney, Heidi began working in law offices at the age of 14. And after graduating from USD, she went on to obtain her JD from Cal Western School of Law, graduating in the top third of her class. During her time as a law student, Heidi concentrated her law studies in the areas of estate planning, tax planning, and corporate business law. The law offices of Heidi Klippel is located in La Jolla and offers comprehensive estate planning and trust services, including trust creation, trust administration, probate, conservatorship, and more. I have copied Heidi's contact information here, and then it's also included in the handouts that you were all given prior to today's presentation. Thank you so much, Heidi, for joining us today.
Thank you, Vania, for that great introduction. So thank you guys for attending today's presentation on estate planning. My goal today is for those of you who have an estate plan. I promise you, you'll learn something new today. But my first focus is going to be on estate planning basics. So oftentimes when people ask me what is an estate plan and do I need one, the answer to that question is, generally speaking, an estate plan consists of a revocable living trust, a pour-over will, a durable power of attorney for financial affairs, and an advanced healthcare directive. The answer to do I need one is the answer is yes, and it's dependent upon age and assets. So what I mean by that is once a person turns 18 years of age, their parents no longer legally have any control over their medical and or financial decisions. So all of us that are adults at a minimum should have their durable powers of attorney in place. The benefit of having these documents is if I were to be driving home and heaven forbid I was in an unexpected car accident and now I no longer have capacity, the purpose of your durable powers of attorney is to give a third party your legal permission to be your financial and or medical advocate when you lack capacity and can't make those decisions for yourself. So if I were in an accident and if I had my durable power of attorney in place, that would give the people listed on that document the ability to accept that nomination, because anytime I put these documents in place, I am just nominating the people I trust. They do have the option of accepting that nomination. And should somebody accept that nomination at any time down the road, they always have the flexibility of resigning. So all of these documents have the flexibility of accepting the nomination to act and also have the ability of resigning should there be a need in the future to step down and turn the work over to the next person listed. So I think that's an important thing to mention. And that applies to all of these estate planning documents, whether it's your will, trust, durable power of attorney, or medical directive. So when I create a durable power of attorney for financial affairs, I'm giving somebody I know and trust my legal permission to manage financial assets that are titled in my individual name. So for example, if I was in a car accident, since my car is titled in my individual name, my durable power of attorney would first give my husband my legal authority to step into my shoes and to sell the car, donate the car, repair the car, whatever needs to happen with the car. And the reason that's important is a lot of married couples mistakenly believe that should something happen to one spouse because they are legally married, they inherently have these powers. But unfortunately, in the state of California, these powers are not inherent because of marriage. You can only obtain the powers to make somebody's financial decisions if you have a durable power of attorney in place. And if you don't have one in place, then you'd have to petition our probate court to become your loved one's conservator. And I hate to use the example of Britney Spears because it really isn't a good example of a conservatorship, but that is part of what a conservatorship involves. Is should somebody lack the ability to make their own medical and or financial decisions, then when that individual hasn't taken the time and hasn't put in a legal document who the people they would trust to make their medical and financial decisions, then anybody can petition the court and say, Your Honor, pick me. I should be this person's conservator because I'm their father, I'm their mother, I'm their spouse, I'm their adult child. And not everybody who petitions the court and gets appointed is always the best person for that job. So I do just like to mention what happens in California if you don't have these documents in place. And probably one of the hardest things that I have to tell people from time to time is it's not uncommon that people will call our office and they'll tell me that their loved one is fully incapacitated and now they need to put their estate plan in place. And I have the unfortunate job of explaining to them that once you lack capacity, you lose the ability to put these documents in place. And if you have these documents in place, once you lose your capacity, you lose the ability to update the documents. So if you have documents in place, whatever happens to be in place at the time of your incapacitation is what is legally controlling and binding. Sometimes people will call me and we'll start the estate planning process, and they might be getting ready to leave the country. And they'll ask me that because they had that first meeting, are they protected? And then I also have the unfortunate situation of explaining to them that until the documents are signed, having a meeting with an attorney legally, with all due respect, means nothing. So anytime you want to give a third party the ability to make your medical and or financial decisions, you do have to have that in a legal document. And that's what a durable power of attorney does as to managing your financial affairs. And also I mentioned a medical directive, which I'm going to segue and talk about a medical directive here for a second. So when you create a medical directive, you're basically picking people you trust to make your medical decisions when you don't have the ability to make them for yourself. Oftentimes your loved ones can make your medical decisions without you having a medical directive in place. But the benefit of having a medical directive is when well-intentioned loved ones of yours are all together and they can't agree on a course of action. So many years ago in the state of Florida, there was a young woman by the name of Terry Schiavo who was unfortunately involved in an accident. She was later deemed to be in a coma in a permanent vegetative state. And her doctors had made the medical diagnosis that life support was prolonging an inevitable death. And her husband was under the opinion that she would not want to be on continued life support in that situation. But her parents disagreed. And because of her parents' religious beliefs, they did not want their daughter to be taken off of life support. So in this situation, because Terry Schiavo did not have a medical directive giving her husband that decision power individually, her parents and her husband went all the way to the Supreme Court of the United States, which not very many cases find their way up to the Supreme Court of the United States. And when you find yourself before the Supreme Court of the United States, I guarantee that you've spent a lot of money. It's a very frustrating and very long process. And sadly, oftentimes you don't get the type of resolution through the legal system that often people are wanting. So it was because of an old college roommate that gave testimony that one time her and Terry were at a bar and Terry had made the comment that she would never want to be in a coma. And based on that college roommate's testimony, the Supreme Court went ahead and gave her husband permission to withdraw life support. And he also cremated her body, which according to her parents and their religious beliefs, they would have wanted her to be buried and not cremated. So my whole point of mentioning poor Terry Schiavo in that situation is well-intentioned people who have your best interests at heart, who want the best for you, don't always agree. And that is where putting an estate plan in place, in my opinion, is a very loving thing to give to your family. Part of why I think it's loving is especially when it comes to your medical directive. Most of us don't sit around the table during the holidays talking to our loved ones about whether we want to be buried or cremated, but your healthcare directive will include that information. And sometimes it's good for your family to know that you don't have a preference as to whether you're buried versus cremated. It's also helpful to include in that document whether you've already paid for and made those arrangements with a third party, whether it's cremation through the Neptune Society or whether you've paid for your burial plots at a nearby cemetery. Oftentimes people want to be buried in a military cemetery that have served. So enumerating all of that in a medical directive can really give your family a peace of mind during a very difficult and sad time. The other thing I like to ask my clients to include in a medical directive is their opinions on life support. Going back to the Terry Schiavo example, you can say in your medical directive that you don't have a preference as to whether you're kept on life support or whether life support is withdrawn, in which case your loved ones can make that decision for you. Oftentimes, I find that the majority of my clients don't want to be on continued life support. A few of my clients do want to be on continued life support. And then many of my clients will give a window of time where they'll say that when that decision is made by the doctor, that in the doctor's opinion, life support is prolonging an inevitable death, oftentimes people might decide that they want to be on life support for a minimum of 5 days before it's withdrawn, but no longer than 30 days. So putting a window of time, I think, is a very loving thing to also include in a medical directive, because with all due respect, when each of us pass away, it's your loved ones that you're leaving behind that are, grieving you. And I have found in doing estate planning for the last 20 years that many of my clients have made the comments that when life support has been withdrawn for a loved one, it has been their experience that the process just went so quickly that they wish they would have just had a little more time, even just 24 hours longer, to grieve, to cope, and to mentally accept the process. So when you create a medical directive, you're usually not making very many decisions in advance, because you do want the person who you're naming to be your medical advocate to make those decisions as they come up on a case-by-case basis with your treating physician. So typically a medical directive is going to only include your preferences on burial, life support, and organ donation. So for organ donation, with medical science being so incredible, there's a lot of things now that they can do with your stem cells, with your organs and tissues. So I ask clients very specific questions about organ donation. Some clients don't want to be an organ donor. Other clients want to donate internal organs only. Other clients will be specific to a specific type of organ, where maybe they're comfortable donating all organs except for their heart or their cornea. I've had other clients that are willing to donate organs and tissues, including donating their skin to burn victims. And then, of course, there's also people that are willing to donate their body to medical research and science. And then there's a group of clients that are also comfortable donating their body to be a cadaver, which is very useful for the advancement of medical fields. So when you create a medical directive, there is language in that document that says that a copy of that document will be treated like an original. So even though an estate plan is typically confidential, which means it's not made public, there's no place that you can go and find copies of a person's estate plan while they're alive. So when you take the time to create a medical directive, I do encourage my clients to attach their medical insurance card to that healthcare directive, because it is important for your loved ones to have your medical insurance information. I also provide a page on the back of our medical directive where people can just handwrite the contact information for the people that they've named to be their medical advocate. I let clients handwrite that information just because phone numbers are subject to change. And then by attaching that to the document, and because it's not in the document, you don't have to update the document as often when people's phone numbers or emails change. So when you create a medical directive, if you're comfortable sharing a copy of that document with the people that you've named in that document, I find that that's a very important thing to do, because sadly, if I got a call in the middle of the night that something's happened to my sister, for example, because I have her medical directive saved onto my computer, I could print that directive and take it with me to the hospital. And once I show the hospital that I'm her first person named in the directive, and I give them proper identification, they will then let me step in and make all of those decisions for her. I also keep a copy of my medical directive and my husband's medical directive in both of our vehicles, so that in case there is a car accident, whether we're going to work or whether we're going on a road trip, I like to have those healthcare directives in both of our cars. I also gave copies of our medical directive to our neighbor. He's not named in our medical directive, but I basically said, if you ever see a police car, a fire truck, or an ambulance in our driveway, would you please give them these documents? And then our neighbor in turn gave us a copy of his directive as well. So I am not suggesting that you go out and give copies of the medical directive to all of your neighbors. That's not my point. My point is, if something sadly were to happen to you, it is a good idea to give a copy of your medical directive to the people that you've named on it, and to people that could likely be that liaison that can get that directive to the emergency personnel. And you can also give a copy of it to your doctor. I know that our doctors scanned our healthcare directives into our file. Our dentist also has a copy of the directive. Hopefully they'll never need it, but it certainly isn't a bad thing to share. And then anytime we travel, I always take our healthcare directives with us. And to be honest, it makes my husband super uncomfortable that whenever we check into an Airbnb or a hotel, I leave our healthcare directives in plain sight. But if you think about it, when you go on these vacations, the only thing that these hotels and Airbnb know about you is your name, your phone number, and your credit card information. So if something were to happen to you while you're traveling, I do think it is important to have that medical directive in plain sight, because it does have the phone numbers of your loved ones, and it does have your medical insurance information, so they can admit you into a close hospital and start treatment. So that's really how a medical directive works. For those of you that might have really old estate plans, it's important to note that prior to 1997, I know that's a long time ago, especially now, but prior to 1997, there was a congressional act that was decided where Congress thought it would be a good idea for people to update their healthcare directives often. So it used to be that if your medical directive was not updated within a 7-year period, by operation of law, that healthcare directive would automatically terminate and it would no longer be valid. Luckily, our Congress people have realized that that wasn't necessarily the most prudent law to enact. So now, once you create a medical directive, it will be effective until you pass away or until you revoke it and replace it with a new medical directive. For those of you who have ARAG legal insurance, which is a great benefit that the UC offers, estate planning is one of the benefits offered by ARAG legal insurance. So you can get your healthcare and durable power of attorneys through ARAG. I just mentioned that because if you have the UCSD insurance, it used to be that if you called the UCSD medical, they had their own version of a healthcare directive. So instead of hiring an attorney, you could actually go through your UCSD medical insurance and get a copy of their healthcare form. It will ask you the questions about who you want to be your medical advocate, first, second, third. All you have to do is complete the form and either have it notarized or have 2 people witness you signing that document. If you're going to have the document witnessed, you have to have 2 disinterested witnesses, which means the people witnessing you signing the document can't be related to you and they can't be named in the document. So oftentimes coworkers make great witnesses and your neighbors make great witnesses. So I do want you to know that when it comes to your medical directive, California has pretty relaxed requirements as to what those documents need to say. So it is okay for you to do that document on your own. But for a durable power of attorney that gives powers over your financial affairs, oftentimes that document is presented to financial institutions, and because of lawsuits and liability, financial institutions tend to be very specific about the language they want included in those documents. So a durable power of attorney for financial affairs is not a document I would encourage you to do on your own, but you can go to your bank because some banks do have their own version of a durable power of attorney that they'll give to you free of charge. And all you have to do is fill it out and have it notarized. So those are your durable power of attorney documents. So now I'm going to talk about trust and wills, because those tend to be really the heart and soul of an estate plan. And the idea of a trust and will, there's a lot of misinformation and confusion out there about those two documents and how they're used in the state of California. So I'm going to start with the basics and just let everybody know that if I died yesterday, to not jinx anything, California has a will for me if I haven't taken the time to write one for myself. And that's something called an intestate statute. So if I died yesterday, and if I didn't have a will or a trust, the intestate statute, which is the California law, that will dictate how my assets are distributed. So in California, if I'm legally married at the time of my death, because we are a community property state, California would give my assets to my surviving spouse first. If I died as a single individual or as a widow, then my estate would go down my bloodline second. So if I had 2 living children, they would then inherit if I died as a single person. It is important to note, though, that in California, there is a bias against stepchildren. So if I'm on my second marriage, hypothetically, and if my husband has 2 kids from his first marriage, if I have 2 children from my first marriage, and to keep the math simple, if we have 2 children together, so there's 6 children between the 2 of us, if I died first without having a will or in trust, under the intestate statute, California is going to give all of my community property to my spouse. So now he owns 100% of all of our assets. And then when my spouse dies, assuming he doesn't have a will or a trust, under the intestate statute is going to give all of our assets to his biological children. So in my hypothetical, I had 2 children from my first marriage. He has 2 children from his first marriage, and we have 2 children together. So under the intestate statute for a blended family with stepchildren, if he died second, my 2 children from my first marriage are automatically disinherited. And our 2 children together and his 2 children from his first marriage are the 4 children that will inherit all of our estate. So when you create a will and or a trust, the benefit of having those 2 documents is you get to decide who's inheriting versus the state of California making that decision. But just to finish the idea of thought on the intestate statute, the hierarchy of beneficiaries is spouse first, lineal descendants second, which would be children, grandchildren, great-grandchildren, but never step. If there are no living lineal descendants going down the bloodline, then we go up the bloodline to mom and dad, but that does not include stepmom or stepfather, only biological mom and dad. And if mom and dad have predeceased, then we go sideways on the bloodline to brothers and sisters, which does include half siblings, but not step siblings. And then we go down the bloodline to nieces and nephews, great nieces, great nephews, but not step great nieces or step great nephews. But it does include, it would be second and third and all the way down. And if we still don't have a living relative, then we go back up the bloodline to grandparents. And then we go to aunts and uncles, first cousin, second cousin, third cousin. And if we still cannot find a living beneficiary, then under the intestate statute, the final and ultimate beneficiary is the state of California. So I will tell you that in 21 years of practicing estate planning law, which isn't a lifetime, but 21 years is a long time to look at a lot of different trust administrations and probates. Not once have I ever seen an estate not have a living biological heir, and not once have I ever seen the state of California inherit from a person's estate. But it could happen, especially if you're from a smaller family. But I do like to explain the hierarchy of that intestate statute. So then let's say I have taken the time and I have created a will. The purpose of the will is threefold. One, it's going to identify a person called an executor. The executor is the person who you're giving your legal permission to handle and administer your estate after you pass away. And that process includes notifying your beneficiaries that you've died. That opens and closes a statute of limitations for any beneficiaries to contest the estate. Their primary duty as your executor is to pay all your bills, make sure that your final state and federal income taxes are all paid and filed and are current. They have to pay any debts that you owe, which include your mortgage, closing credit cards, funeral, hospital. And then they're going to take the net estate, which is that value of assets after all the debts have been paid. They're going to read the will as to who your beneficiaries are, and they're going to make distributions accordingly. You can also include in a will who you would want to raise your minor children. So for any of you who have minor children, at a minimum, you would want to have a will in the state of California, because that is the legal document where you identify the legal guardians of your minor children. And just like in my example with the durable power of attorney, anytime you nominate a legal guardian to raise your minor children, you are just nominating them. So they do have the ability to say, yes, I will do this, or no, I won't. If anybody you nominate in this document is incapacitated at the time of nomination, then they're no longer eligible to act. So a person does have to have legal capacity in any of these documents to be eligible to act. So for example, if I nominated my dad to be my children's legal guardian, but then by the time I pass away, if he's now incapacitated, it's almost as though he's not nominated and we skip to the next person, because for obvious reasons, you don't want to give an incapacitated person the ability to raise minor children or to be your medical or financial advocate. So just know that anytime a person does lack capacity, that nomination to them is null and void, but only if you have a legal document that acknowledges that they lack capacity. So if a person is starting to show signs of lacking capacity, but there's no formal diagnosis in place, then technically that person could accept that nomination. So for those reasons, if you do have a loved one that you've named on these documents who sadly is starting some of the early stages of losing their capacity, you might get to a point where you might want to go ahead and update those documents and be proactive about that update, because there is a gray area in the law as far as capacity goes, where sometimes people can be super sharp in the morning and have capacity, and then twilight as the day goes by. And that's kind of a gray area in the law where the law is not totally clear. So just to avoid any chances of somebody who's in that kind of in-between stage, if you have a loved one named in your documents who's in that situation, I would encourage you to do an update and to take them off of your documents. It just makes things a lot cleaner. So when you have a will, it's really important to understand that a will does not keep us out of the court process called probate. So when a person dies, there's a court process called probate where sometimes a person's estate has to go before the courts. The reason why a person's estate would have to go before the courts is two situations. One is if I died and if I owned real property and if I was the last surviving owner of that real property, California views real property as being unique. So anytime you have real property that's not titled in a trust, it's always going to have to go through that court process called probate before that asset is distributed to your beneficiary. So it's really important to understand that when you have a will, if you own a house, having a will does not avoid probate, because you have a house that's titled in your individual name. When you die, that house will trigger probate, but your will be introduced into the probate process, and the judge will be in charge of making sure that all the due diligence occurs in the probate of notifying the beneficiaries, paying all the bills, and then ultimately distributing those assets to the beneficiaries. The problem with let me actually back up and say the other thing that triggers probate. So there's two things that trigger probate. One is the real estate not titled in a trust. The other one is if I died and if I had assets that were titled in my individual name, and if I didn't have a beneficiary attached to that asset, if you added all of those types of assets together, and if their total aggregate value exceeded $166,250, then those assets would also trigger probate. So if I had a will that gave everything to my husband, and if I had a bank account in just my name, and let's say I had $2 million in that bank account, if I named my husband as my pay on death beneficiary, and as long as my husband survived me, then that account would not go through probate because you have a living beneficiary attached to it. Okay, so there's a question about, can a house be transferred on death? Document for this. What about contents of house? So anytime you own real property in the state of California, you want to have a trust, and you are going to have a document that is called a quitclaim deed that transfers the title of that house from you as an individual, or from you as a married couple or a joint tenant or tenant in common, to you as the trustee of your trust. So when you create a trust, which is why so many people in California have trusts, it's because they're homeowners. That's why so many people have trust, because in California, when you create a trust, you want to think of your trust metaphorically like a bucket. So when you first talk to an estate planning attorney, you're basically going to be making decisions about the size, shape, and color of your bucket. Who are your successor trustees? Who are your beneficiaries? And what assets are going to go into that bucket? And then once the trust is signed and notarized, that's when the bucket exists. And that's when you're going to have a quitclaim deed recorded that's going to transfer your interest in the real property into your trust. When you create that trust, there's also a document called an assignment of tangible personal property. And that's the document that transfers all the contents of your house into your trust. So when an assignment of tangible personal property is signed and is notarized, everything inside of your house is automatically deemed part of the trust. Your couch, your jewelry, the artwork, the furniture. And what happens in California is when a person passes away, all assets that are titled in the name of a trust and all assets that name the trust as a pay on death beneficiary always avoid probate. But that applies to your real property and your taxable assets only. So when I create a trust, I'm going to put my house into that bucket. I'm going to put my checking and savings accounts into that bucket. I'm going to put my money market account into that bucket, my certificate of deposit into that bucket. I'm going to update my life insurance to now name my trust as the beneficiary. So my life insurance goes into that bucket. If I own a timeshare, I'm going to call the timeshare company and have the title updated. So now that the timeshare is titled in the name of the bucket. If I own a business interest, if I have an S Corp or a C Corp or an LLC, I want to update my business ownership so that my stock certificate is titled in the name of my trust. Or if I have an LLC, or if I have real property titled in an LLC, I want my membership interest in the LLC titled to me as trustee of the trust. The only asset that you have that doesn't go through the trust are your tax deferred assets, which includes annuities if you have those, and retirement assets. So anytime you have a 403B, an IRA, a 401k, a simple, a SEP, any kind of a tax deferred asset, for those assets, you always want to name individuals as beneficiaries. And this is an important time just for me to mention, for any of you who have an existing estate plan, one major change in the law from about 7 years ago going back is it used to be that all of us estate planning attorneys, when it came to your retirement accounts, 15, 10, 7 years ago, we used to ask clients to name their spouse, if they're married, to be their primary beneficiary on all of those retirement accounts, because under federal ERISA laws, your spouse can consolidate retirement accounts. They're the only person who legally can consolidate those types of assets. And then we would encourage you 7 years plus ago to name the trust as your secondary beneficiary on your retirement accounts. So it's important for those of you who have an estate plan to know that we no longer want the trust coming on as a beneficiary on any of those tax deferred assets, and that's for tax reasons. So tax laws change, estate planning laws change, probate laws change. And that's why for any of you who have an estate plan, it is a good idea to always be updating and reviewing those documents. From a legal point of view, the language in the documents becomes stale, for lack of a better word, about every 8 to 10 years. So there's something called an amended and restated estate plan, which is when you can take the name of the trust and the original date of the trust, and you can update all the language in the trust. But because you're keeping the original trust name and date, all of the assets that you put into that bucket stay in the bucket. So you do want to update your estate planning documents about every 8 to 10 years because the legal language needs to be updated. And that is primarily because the tax laws change. And this is a perfect example. 7, 10, 15, 20 years ago, I always asked clients when it came to retirement accounts to name spouse if they're married first and to name their trust second. If they're not married, I would tell them to name their trust first. Now those laws have changed that if a trust is named as a beneficiary on a retirement account, because a trust is a legal entity under the law, it has to take a lump sum distribution. And anytime you take a lump sum distribution from a retirement type of an asset, you're usually going to trigger an unnecessary additional tax. And because a trust becomes irrevocable at the time of your death, irrevocable trusts are taxed at the highest allowable federal tax bracket. So if you have the trust named as a beneficiary on any of your retirement accounts, it's almost like a double whammy because you're creating an unnecessary taxable situation that could be avoided if you named people or charities as those beneficiaries. So for those of you who have an estate plan that's been in place for about 5 to 7 years or longer, I would encourage you to look at your retirement beneficiaries. And if you have named your trust as a beneficiary, I would encourage you to go ahead and update that. By updating it, you can name anybody you want. Your retirement beneficiaries don't have to be the same people that you have named in the trust as beneficiaries. You could give one retirement to your sister. You can give another retirement to your best friend. You can give another one to your children. You can name whoever you want those beneficiaries to be. But for all retirement accounts, I always want to make sure that you have 2 layers of beneficiaries. You always want a primary beneficiary named, and you always want to have a secondary named as a backup in case if the first person or people listed predecease you, if you don't have a living beneficiary attached to those assets, if that asset plus anyone like it where there's not a living beneficiary attached to it, if those added together, if their total aggregate value is over that $166,250, then that will trigger probate. So just know that another common misconception in California is people falsely assume that once they create a trust, they're done. Since they have a trust, that's all they need. They have all of their affairs in order. But what actually happens in California is when a person dies, one of the first things that I tell their trustee or executor is that they have to look at how all of their loved ones' assets are titled, because it's how your assets are titled at the time of your death that determines whether or not we're going through probate. So I'll oftentimes create a trust, I'll prepare a deed, I'll put a client's house into their trust. And then in the future, the interest rates drop super low, and understandably, people take advantage of these low interest rates and they refinance their house. So if I put a client's house into their trust, but if they later refinance, oftentimes when you refinance, unbeknownst to you, the mortgage company is taking the house out of the trust for the refi. And unless you give them specific instructions telling them to put the house back into the trust at the close of the refi, there's a 50-50 chance that you could start off with the house being in the trust. And then when you finish the refinance, the house has now come out of the trust and you have no idea. So one of the things we always do is anytime we're doing an estate plan update for a client, we always pull title. We get title through a title company that we work closely with. And so we always check, and every so often we'll find that somebody's house was taken out of trust during a refi. And 9 out of 10 times when we asked the client about this, they had no idea that their house came out of their trust. So again, for those of you who have an existing estate plan, if you have taken advantage of these super incredibly historically low interest rates over the last couple of years, I would encourage you to look at your property tax statement. By looking at your property tax statement, how it's addressed is usually going to tell you whether or not your house is in the trust. So if you pull your property tax statement, and if it has your name with the word trustee next to it, or if you see the abbreviation for trustee, TEE, or if you see the name of your trust, then you pretty much can know that your house is titled in the trust, which is how you want it to be. But if you pull your property tax statement and if all you see is your name or you and your spouse's name without any reference to trustee or TEE, which is the abbreviation of trustee, or the name of your trust, then chances are somewhere along the way the house came out of the trust and it's not in the trust. So remember, in California, if I died yesterday and if I had a current up-to-date trust, but if my house was not titled in my trust, then that house will go through probate. So another common question people will ask me is, if I died and if my house wasn't titled in my trust, but all of my other assets are, what is subject to probate? And that's a great question. So the answer to that question is when I die yesterday, and if my house is the only asset that's not titled in my trust, only that asset goes through probate. All the assets that are in the name of the trust, or all of my assets that have living beneficiaries tied to them, those assets never go through probate. So another important thing to mention, which is another common misconception, is sometimes people think that once they put their estate plan in place, they think that because they're putting assets into this trust bucket, because these assets are now in the name of a legal entity, that somehow these assets now have additional creditor protection, but they don't. So one really important thing to understand about estate planning is when you create an estate plan, you are having the protection of naming people to be your financial advocate so that we don't have to go through a conservatorship process. That's a huge benefit of an estate plan. Another benefit of an estate plan is by having assets properly titled, we're going to avoid probate, which is another huge benefit of having an estate plan. But when you put your house, for example, into the name of your trust, because the trust is revocable, which means it's amendable, which means it's changeable, which is how you want it to be, those assets that you've put into the trust are still reachable by your creditors. So you still want to have a good umbrella policy on your house. You still want to have good homeowners insurance insuring your house. You still want your assets to have the FDIC insurance anytime they can, especially with the bank scares that have been happening lately. So just know that when you create a trust, there is no creditor protection by having assets in a trust. Creditors can still go after those assets and lien those assets just like they could if those assets were in your individual name. So when you create a trust, another benefit of having a trust is you can put contingencies in a trust that you can't put in a will. So if you were to quid pro quo the benefits of a trust versus not doing a trust, when you create a will, because a will might have to go through our court system, you can't put contingencies in a will because the courts just do not have the time or the personnel to oversee that. So in San Diego County, we have 3 sitting probate judges, and those probate judges are hearing trust administration matters, probate matters, conservatorship matters, guardianship matters, and estate litigation matters. So those are 5 very busy areas of the law that only 3 judges are listening and dealing with. So our probate court, understandably, as you can imagine, is pretty inundated, and their calendars are really full. So when you create a trust and when you name a person to be a successor trustee, because those assets don't have to go through the probate courts, you can put contingencies in a trust that you can't put in a will. So for example, my husband and I have 2 little kids. If we didn't have a trust, and if we had a will or didn't have a will, through the probate system, when each of our children turned 18, under California law, they're entitled to all of their inheritance on their 18th birthday. But when you create a trust, because you have a trustee who's basically in charge of managing those monies and investing those monies, you can have beneficiaries regardless if it's your children, grandchildren, nieces, nephews, best friend, neighbor. You can put age contingencies in place for them. So our trust says, regardless of our children's ages, they can ask for distributions for their health, education, maintenance, and support. So for example, when our kids go off to college, they can ask for distributions from the trust to help pay for their tuition and their living expenses and their room and board. But our trustee also has the ability to say no. So if one of our kids was flunking out of college, our trustee could withhold the monies and say, pull up your GPA. I'm only going to keep making these tuition payments if you have a C grade point average or higher. So your trustee has a lot of discretionary decision power. So when it comes to picking a trustee, you really want to pick somebody who's like-minded, who has similar monetary values that you have, because they do have a lot of discretion, and that's for good reason. And then we said in our trust that when our kids graduated from college or turned 25, whichever occurred first, we gave them 5% of their inheritance. So that first distribution is intentionally small because statistically it's that first distribution that's spent within a 2-year period. So we gave our kids just a little bit of their money first time out of the gate. So if they're not so financially astute, hopefully they learn their lesson on that very small distribution of 5%. And we said 25 or college graduation because not everybody wants to go to college, which is fine. But if they do go to college, then they get the monies a little sooner. So we were honestly trying to dangle a carrot, like maybe you should go to college because you'll get this money earlier than if you don't. And then we said when our kids turned 30, they got a third of their inheritance, not half, but we gave a third, thinking at age 30, they're buying a house, they're getting married, they're having their own children. So getting that next distribution would be very helpful. And then we said at age 35, they would get the final distribution. So that's how we structured our estate plan. A lot of clients like that distribution scheme. I had a client from the UC who I will rename, who shall rename nameless, who basically said that their child would inherit when they got a PhD or turned age 70, whichever occurred first. So there's a myriad of things you can do as far as the distribution. I have had some clients that like to give distributions based on their tax returns. I personally am not a big fan of that because I feel like you're almost saying the more money you make, the more valuable you are, so here's more money. So sometimes I think that can incentivize the wrong thing. But my point in saying all of this is it's your estate plan. So the great thing is you get to put whatever contingencies that are important to you. It's not a one size fits all. I've had some clients give monies at age 18 because they feel like their children are very knowledgeable and financially mature at that young age. I've had other people who hold monies in trust until their child goes on Social Security because they want to make sure that this bucket of money is kept open as a backup plan. So again, a myriad of solutions, not a one size fits all. Everybody's situation is different. I also ask clients whether they want to put a drug testing clause in their trust. If they do, I usually write it to be an optional clause. The purpose of this clause is if my child had a heroin addiction, which I use heroin on purpose, it's a horrible addiction. I wouldn't want my trustee to have to give my child $300,000 cash because God knows what a person can do with that kind of money when they're suffering from an addiction. But my trustee could drug test the beneficiary, postpone a distribution to that beneficiary, but use those monies to pay for the beneficiary's rehabilitation if the beneficiary is willing to go. So the drug testing clause is really, it's worded in a way that it's a very loving clause, but you know, if my sister passed away and if I was the trustee in charge of my nephew's inheritance, the one thing I wouldn't want to have to do is give him a whole bunch of cash if I knew he was struggling with addiction. And then another optional clause I ask clients about is separate property. So when my husband and I pass away and our 2 kids inherit, if they are married, an inheritance is an exception to the community property law, but the way it works is if my daughter inherits money from us and if she keeps it in her own account in her own name, then if her husband had any kind of liability, those inherited assets are protected, but their community property assets are reachable by spouse's creditors. Just like if she were to inherit assets and if her spouse and her were to get a divorce, community property is divisible in that divorce proceeding 50-50, but inherited assets are the exception and they're not part of a divorce in California. But a lot of people don't know our community property, separate property laws because they're kind of quirky. So when you put this language in a trust, what it does is It's a stipulation that would require a beneficiary who's married to have to create an account that's in their own separate name, and the trustee would make that beneficiary's distribution payable to that separate account. The benefit of doing that is, should that beneficiary later get a divorce, those monies that they kept in that account are protected. But on the flip side of that, if that beneficiary wants to buy their spouse a car, for example, they can take monies out of the separate property account and put them into their spouse's name, and that's a gift of separate property into community property. So you can share the monies with your spouse. It's just, should there be any liability from your spouse's side, those inherited assets would be protected. And should there sadly be a divorce, those inherited assets would also be protected. So that's an optional clause. Another optional clause that I ask clients about are pets. It's really sad that sometimes pets are euthanized because there's not language in place to give the trustee the ability to place the animals with family, friends, or a no-kill animal shelter. So that is something we also ask clients about. We've written honorary trusts, which are a special type of a trust for animals that have a long life. Parrots and tortoises, for example, tend to live over 100 years. So chances are, if those animals will outlive their owners. So we've done special trusts just to make sure that those animals are cared for and taken care of. And then, of course, there's other provisions we can put in place when you have little kids. We could ask about whether or not you'd want your minor children to be kept together. So if the guardian says, I've only got room for 2 of the kids and not all the kids, then we'll skip to the guardian that will keep all the kids together in one home. I ask clients about umbilical cord blood storage, if they've paid for that, because if they have, the trustee should have your permission to continue to make those storage payments. We ask about whether clients want to give their trustee permission to pay for grief counseling to help their loved ones cope with the loss of them. Religious upbringing, if you want your guardian to raise your child in a specific religious household, or if you prefer that your guardian not impose their religious beliefs on your children, we ask about that. We also ask about whether you'd want to give your trustee your permission to acknowledge the educational milestones of high school graduation, college graduation, and an advanced degree. We also ask about a wedding gift. If your child was getting married for the first time before they've inherited from the estate, would you want to give your trustee permission to give them a wedding gift? And would you give the trustee your permission to decide what that wedding gift looks like? If the trustee deems it to be a more viable marriage, maybe they're more generous with what that gift looks like. But I do limit it to a first wedding only, which would include an annulment, because I don't want people to try to get greedy and get married and get an annulment and get remarried and try to collect money each and every time. Because with Vegas only 6 hours away, that would be a pretty easy thing to abuse. So we anticipate that and put parameters in place. And then the last question I tend to ask people with minor beneficiaries, whether they're children or grandchildren or nieces or nephews, is if a beneficiary could qualify to buy their first house based on their income history, which means their credit eligibility without the use of trust funds, would you want to give them a down payment towards the purchase price of that house? So as you can tell from all these examples, one of the best things about putting an estate plan in place is you get to make all of these decisions. When you don't have an estate plan in place, and should you later lose your capacity, once you've lost your capacity, you have lost the ability to put these documents in place. And once that happens, it's really up to somebody you love and trust on their own volition and at their own expense to petition the courts to become your conservator. And that's not an easy thing to do anymore. It takes time, it costs money. It takes time, it costs money. And in today's busy world, people are so busy that, it's not always an ideal situation just to wing and hope and a prayer that if something happens, somebody's going to step up and want to advocate for you. And again, when you put an estate plan in place, because it's almost like a car, for lack of a better metaphor, and it needs to be tuned up and updated about every 8 to 10 years, that does give you an opportunity with fresh eyes every 8 to 10 years to review who your successor trustees are, who your beneficiaries are, and you can update those decisions accordingly. Granted, you can always update your estate plan prior to 8 to 10 years, but I know that people like the peace of mind of knowing that they can go that long without having to do an update. Another question people will often ask me is, who's a good trustee choice? Because a trustee's primary job is to manage finances, a good trustee choice is somebody who's good with money, because if you were to lose capacity, the trustee's primary job while you're alive is to pay all of your bills when you lack capacity and can't pay those bills for yourself. And then when you pass away, your trustee's job is to administer your estate. So you want a trustee who your beneficiaries know and trust. You want a trustee that's going to treat your beneficiaries fairly and impartially. You want a trustee who's a good communicator, who's going to be in correspondence with your loved ones, explaining where they are in the process. Because when you are a trustee, you are under a fiduciary duty, which is the highest duty imposed by law. And basically what that means is if you make a mistake in the management of funds, even an innocent mistake, those beneficiaries have the ability to take you into court, and judges take the role of a trustee very seriously. So when you think of a trustee, if you have adult children that are financially responsible, and as long as the kids have a good relationship where if you picked one of them, the other one would trust the decisions of that one. I always like having family in place first, whenever that's an option. The law does not expect your family to know how to be a trustee, but because you're picking a loved one to do that job, these documents do give them your permission to hire a professional. Usually if people come in and spend 30 minutes to an hour with me, they walk out of here knowing exactly what it means to be a trustee, and they're able to do it. So I'm not a big proponent of naming lawyers as trustees, because lawyers charge a lot of money to do what is normally a pretty straightforward job. With all due respect, I mean, because a trustee's primary job while you're alive is to pay all of your bills, most people can handle that, but you need somebody who's reliable and who's trustworthy, because you're entrusting them to be your financial advocate when you are at your most vulnerable moment and you don't have capacity. So you don't have the wherewithal to be looking at what they're doing and how they're doing it. I know sometimes I have clients that come in and they're at a point in life where they're slowing down. They're not as mobile as they used to be, or they're not able to drive any longer. And sometimes it is a good idea to nominate a loved one to become what's called a co-trustee. When you bring on a co-trustee, you have the ability, while you have capacity, to teach them about the management of your finances, what bills you pay, how you pay them, logins, passwords, so that way, should you lose capacity, you have somebody in place who's familiar with your assets and debts, who you've already taken the time to teach about the logins and passwords and the management of your financial affairs. So it's not as though you have to wait until you lose capacity to have these powers go to a loved one. It is often a good idea that if you get to a point in life where maybe you are slowing down, or if you have a diagnosis that involves a diminishing capacity, usually those are the two times where it is a prudent and a good idea to update your documents to bring on a co-trustee, to give them your financial permission now to start helping be your financial advocate, so that you can teach them about what that looks like while you have the ability. And then the other thing I just want to mention is, when you create an estate plan, like I said, it's not a one size fits all. At a minimum, you are going to want to have your durable powers of attorney in place, because it's your medical directive where you nominate people to be your medical advocate if you don't have the ability to make your own medical decisions. That is the only document I do encourage you to share with your loved ones. And as I mentioned earlier, I keep a copy of my medical directive in my car in the glove compartment. My neighbor has a copy, and every single person that I've named on the document has a copy. My primary physician scanned it into my medical file. My dentist scanned it into my file. My dermatologist scanned it into my file. So the more doctors that you work with that you're comfortable sharing that medical directive with, I would make sure that they have a copy of it. Just be mindful that in the future, whenever you update that document, you're going to want to give the updated document to anybody who had the old document. If you update that document and now you're taking somebody off of the document, I would let somebody who had a copy of the old document know that you've updated the document and that they can just shred the old one. Oftentimes people don't put two and two together, that they're not necessarily on the new one, but for all of those reasons, it's a good idea to keep a list of who you've given that medical directive to, so that in 8 to 10 years, when it's updated, you can always have the people who have old copies destroy those old copies, and you can give the new version to the new people that are on those documents. And then the durable power of attorney, that's really important. If I'm hit by a drunk driver, which is never expected, it's never planned, it's never convenient for that to happen. The durable power of attorney gives somebody my permission to deal with assets that are in my individual name, my retirement accounts, my car, filing my state and federal taxes. But my trust is going to give the same person, because you have the same person on those two documents, my legal permission to deal with all of the assets that I've titled in the name of my trust, like my house and my bank account and my life insurance. So when you lose capacity, there's two documents that give financial powers. One is the trust, and that gives powers over all assets that you've titled in the name of the trust. The durable power of attorney gives all financial powers over assets that are still in your individual name. And then when you pass away, the durable power of attorney passes away with you, and it gets replaced by your will. So when you pass away, any asset that's titled in your individual name, like a car, that doesn't have a beneficiary tied to it, like a car, that's when the will comes into play. And basically, when you have a trust, you have a special kind of a will called a pour over will that directs for any asset that's titled in your individual name to be titled into the trust after you die. But just know that even when you have a pour over will, there's still a possibility of probate if there's real property that's titled in your name that's not titled in the trust, or if you have assets titled in your individual name that don't have a living beneficiary tied to it, who, when you add all of those types of assets together, their total aggregate value exceeds the $166,250. So I have sadly seen situations where people have a trust, but we still have a probate. I had a client who had an annuity that she acquired after she did her trust. And even though she should have put people as beneficiaries, for whatever reason, she put the beneficiary as the estate of, and she put her name. That legally is not a viable beneficiary. So because of that annuity, that one asset did have to go through probate. I did send a, I sent a handout via email to everybody prior to this Zoom. I'm trying to get onto the chat on this computer. If by chance you didn't get the handout that I emailed last week, there's my email address. And if you have any questions that you might want to talk about individually, that is my phone number. But thank you guys all for your time today. I hope it was informative for those of you who don't have an estate plan. I hope you have a much better idea as to what an estate plan is and how it works. And for those of you who have an estate plan, I hope you got some good insights as far as making sure that your house is titled in the trust if you've refinanced, and updating your beneficiaries on your retirement accounts to make sure that you don't have your trust listed, because those are two very big changes in the law over the past 10 years. So thank you everybody so much. On that, I guess we'll go ahead and end our Zoom today.
Thank you so much, Heidi. This was very informative. Thank you.
Thank you. Have a good day, everybody.